Hey everybody, thanks for joining. This is a special edition of Will Wednesdays. Estate planning is for everyone. We're trying something new with the PowerPoint as the background. Let's just go ahead and do it. And let me give you a quick reminder that the information here is just for informational purposes only. If you have any questions, contact your local attorney or email me at greg@tricylawyers.pro. Estate planning is for everyone, demystifying one of the most important things you will ever do. A little background information about me. Originally from New York, law school at Campbell right here in Raleigh, North Carolina, MBA from Bowie State University, and undergrad from University of Pennsylvania. I have a family, 4 children, one beautiful wife, and one thing I'm most proud of here is I did publish a book called ABCs of Money for Girls and Boys. That's available on lulu.com. It's a great book. It looks at introducing concepts like what is a bank, what is a credit to really young children with some great images. Check that out if you're interested. I love outdoor activities. But this is why you are here today. We're going to cover some common estate planning questions, important reasons to do an estate plan, what is a trust, last will and testament, and other important documents. What are some of those common questions? So what is an estate plan? So it really covers these 3 major topics here. Incapacity planning. How do you want things to flow? Who do you want to be in charge of your assets if you can't make those important decisions? Death planning. How do you want your assets to be distributed? And then legacy planning. How do you want your dreams to be carried on? How do you want your loved ones or your children to carry on with your assets in the future? Incapacity planning, death planning, and legacy planning. That's what estate planning is really all about. My background is I worked as a financial advisor. I've been a trust officer at a regional bank. So I've always been in this environment of helping people build wealth, save for the future. And now I'm working with individuals to pass that wealth on to the next generation. And it doesn't have to be large wealth. Everybody has a plan, no matter if it's big or small. It doesn't have to be a large plan. So even if you have small assets, you still need an estate plan. What if you don't have an estate plan? I get this question all the time. Well, if you don't have an estate plan, the state has a plan for you. Each state has their own set of laws that will determine things like how your finances are going to be handled, how your health is going to be handled, and they could even determine who's going to take care of your minor children. So if you want to have a hand in making those decisions, you definitely want to get your estate plan together. What is probate? When you pass away, eventually everyone's going to pass away. When you pass away, your estate has to go through probate. Like I said earlier, whether you have a large amount of assets or a small amount of assets, your estate still has to go through probate. Everyone has an estate, not everyone has a plan. So what literally happens is the executor or personal representative of your estate has to go down to the county court, the clerk of court in the county where you live, and open up an estate. That might cost like $120, $150, and then have to make an inventory of your assets, contact creditors, finally make distributions to beneficiaries, and then submit another document saying to the clerk of court, this is how the assets were distributed. And that process can be very long. It can take 6, maybe 12 months, all depends on how complex your estate is. But that probate process is just something you should be aware of. Some of the downsides are that it's expensive, time-consuming, and it becomes a matter of public record. When do you need probate? When you own assets. When you pass without a will, that's saying that you died intestate. When you died without a will, or when you died with a will, that's called testate. Now, in some cases, some people do want to go through probate. Let's say you have a creditor that you've had a dispute with. Well, you know what? That creditor has to respond to a publication in the newspaper. And if they don't respond within that, let's say 60 or 90-day window, then that debt is extinguished. So in some cases, if you have a debt and you have a dispute with a creditor, you want to actually go through probate. Now, I would definitely recommend considering hiring an attorney to help you through the probate process, especially if you name your spouse as your executor, because that's a very emotional time. They're just still dealing with the grief and loss of their spouse, and that's a lot to put on the surviving spouse to handle all of these things. So definitely consider working with an attorney when it's time to go through the probate process. Can I avoid probate simply by adding someone as a joint owner? Now, I think that's definitely a good idea. I always ask clients, do you have your spouse or a loved one name down on an account, brokerage account, bank account? There are some downsides to that. For example, uh, you can expose that account to the other individual's creditors. Now, it's definitely a good idea. You want to have a transfer on death designations, pay on death designations, and those things basically say, well, if I pass away, this is going to be the person that's going to take over these assets. Now, definitely a good thing to have in place. Just be aware that it can make those funds available to the creditors of the recipient. So just take that as knowledge before you go ahead and make those decisions. But I definitely think those are great ways to transfer assets from one individual to the next. Now, what are some estate planning solutions? Fantastic. Let's talk about those. One thing that we often don't talk about is creating a revocable trust. Now, I grew up in let's say, middle class neighborhood in Long Island. My parents are both from Panama. We weren't poor, we weren't rich, we were doing okay, but we never talked about having a trust. And I think that in every family, you should have this conversation about, well, what is a trust and do we need one? And the trust, ladies and gentlemen, is just a legal document. Okay, and that legal document really has no effect until that trust is funded. Now, what does that mean? That means that instead of you owning your house, instead of you owning your bank accounts, the Thomas Family Trust, if Thomas was your last name, would become the owner of that house, any real estate that you own, and the owner of those bank accounts. Now, notice them here, we have across the retirement accounts. You don't put retirement accounts like a 401k or IRA into a trust because those things have their own beneficiary designation, and you don't have to worry about how those assets are going to be distributed as long as you keep those beneficiary designation forms updated. Okay. When you create a trust, it's a legal document and it's going to contain your wishes. And what's nice about it versus, let's say, a simple will is that a will only takes effect upon death, but a revocable living trust can take effect upon incapacity. Okay. You name yourself as the grantor because you're funding the trust. You're also the trustee because while you're alive, which means it's revocable, you can make decisions about what assets are in the account and how you want those assets to be distributed to you or to your loved ones. Let's go forward. Now, how does the trust accomplish my goals? After you pass away, or should you become incapacitated, then the person or persons that you named as successor trustee, they take control, and then they will distribute those assets according to your wishes in the trust to the beneficiaries. And why is this young lady down here smiling? She's smiling because there is no probate associated when there is a trust. Now, literally, I had a client call me and she sounded relatively young. And she said, you know what, I want to set up a trust for my family. And I said, you sound pretty young. I'm always curious about people's motivations. I said, why do you want to do that? She said, well, a close family member of mine passed away 8 months ago, and we're still going through the probate process. And she said, I don't want to make this process difficult for my family members and loved ones at all. And that's why I want to set up a trust. So definitely something to think about. No probate. She's happy, and the assets get distributed to your beneficiaries the way you want. You can break it up by different amounts, let's say different times. So let's say you want assets to be distributed at ages 20, 25, and 30. Those type of instructions you can put inside of a trust. Important reasons for estate planning. As I mentioned earlier, you definitely want to name a guardian for your minor children. That way the state doesn't have to do that, which could be contrary to your wishes. You can set up a trust for your minor child's assets. So if your child is 18 or less than 18 or less than 21, depending on the state, and let's say they're just not knowledgeable or very good about money. So you can use a trust to, once again, put some guardrails around when they get those assets, who's going to be in control of those assets for that child, and even how they can use those assets. Let's say if you want that money to be dedicated for their education, those types of instructions you can put inside of the trust. Now, I do want to mention, you definitely want to be very, very clear. A very interesting example of where things can go awry in a trust is if you look at the ownership structure of the Denver Broncos. There's been a lot of back and forth in that family because the Denver Broncos football team was actually put into the trust. And the father, the owner of that team, he had several children. And he wasn't clear about which child was going to be in charge of running the team, who's going to be in charge of the assets. So there's been some infighting and dispute in that family about, well, who should be in charge, who's next in line. So if you do put instructions into a trust, make sure that you make those instructions clear. Others who may need help protecting their inheritance. I put a picture here of a doctor because sometimes doctors can be targets of lawsuits because they're in a high-risk profession. And so you can definitely use a trust to kind of segment assets from a doctor versus his family or a doctor versus his spouse. Other cases, you might just say, well, you know what, this person is not that good with money, or this person is struggling with a drug problem. I want to make sure that they go through a rehab facility first, and then I'll disperse the assets. So there could be several different reasons why you want to use a trust to just basically control how the assets are going to be distributed. Protecting all members of a blended family. So this is a perfect example. Let's say Mary and Jake here, let's say that they are both on their second marriage, and Mary had children from her prior marriage, Jake had children from his prior marriage, and now they have children together. Well, and often what happens is Mary and or Jake want to make sure that the children from their first marriage receive the assets they've accumulated when they die, and they don't want Mary doesn't want her assets to go to Jake's kids and vice versa. And so that type of specific language you can build into a trust. So you definitely want to consider doing some estate planning if you're in a blended family. Other agreements I'm sure you've heard of are prenuptial agreements and divorce settlements, but you can definitely use a trust to help direct the assets when you have a blended family. Any family member that might have special needs, you definitely want to consider having a special needs trust set up for them. There's some specific language that you can use. Let's say that special needs person is receiving government benefits and you don't want any assets coming to them from the trust to disrupt those government benefits. There's some language you can build into your trust to help with that. Or you can just have the trust set up with specific language such that specific needs are taken care of by the trustee for that individual with special needs. So definitely consider a special needs trust if there's someone in your family that needs that additional protection and attention. If you own a business, now when I deal with business owners, I immediately ask them, where's the succession plan? Who's next in line? Do you plan to sell the business? Are your children currently members of the business? Are they going to inherit the business? So there's several different questions that come up. Are you passing ownership of the business in the will? How is that going to impact your children's taxes? Have you spoken with your CPA? So there's lots of planning that should go into setting up your business affairs, how they're going to pass on to the next generation. Does your operating agreement speak to what should happen if someone passes away? So there's many different things. If you're a business owner, you definitely want to speak to your accountant and your attorney to make sure that you have an estate plan in place to pass that business on or sell it in the appropriate way. What about Fluffy or Fido? So I often ask right off the top, do you have a pet? And if I'm asking if you have a pet, it's because I want to know, is there going to be a pet trust? And is it going to be a pet caretaker? The pet caretaker, the pet caretaker is going to be the one who's going to take care of Fido or Fluffy or that cat or bird when you're no longer here. And then the pet trust is just a set aside, some money, $500, $1,000, $2,000 that you want to give to that pet caretaker to take care of that pet. So definitely something to think about. You can leave that money outright, or you could leave it in a trust. It's just a nice way to help the next person take care of that family loved one. Other important estate planning documents. We often talk about things in terms of a will package. So when somebody says to me, Greg, I just want a will, I said, well, that's great. That's kind of like just the entry level of estate planning, but you should at least consider a will package, and that's going to cover some of these documents here. So the last will and testament, remember, it only becomes effective at death. It must be submitted to the probate court, and it's really going to handle, here's the major things you need to think about. Number one, who's going to be the executor? You should ask yourself two questions. Number one, who's responsible? And number two, who's going to be willing to do the job? That's how you go about choosing an executor for your will. And then the next thing you want to think about is, if I have minor children, who are going to be the trustees of the accounts for my minor children? Next thing you want to think about are there going to be any specific gifts? Do I have a unique coffee table? Is there some family jewelry that I want to give to a specific individual? How do I want to list that out? And then think about who's going to receive the remainder of your assets, your tangible personal property, your real property. And then I always ask people, who's going to be your remote contingent beneficiary? So let's say that everybody that you named to be a beneficiary is no longer available. Who else, what person or organization would you want to receive those assets if nobody that you named earlier is available to take? Once you have those things in place, you're just about ready to go ahead and get that will together. A pour over will. Now, if you start with a trust, and if you're doing an estate plan, the trust typically will come before the will. If you have a trust in place, then your will be much smaller, because your will becomes a pour over will, and your pour over will is basically used to cash accounts or property that were not put into the trust. And one section of that will is going to say all remaining assets should flow into the Thomas Trust. That's what we talked about earlier. So pour over will is the will that you use when you have a trust in place. Your financial power of attorney, sometimes called the general power of attorney. This document is where you name agent number one and agent number two to take care or control of your assets if you're not available. Now, typically you can have it set up as one that's springing or immediate. When we write them, we tend to write general powers of attorney that are immediate, because if that general power of attorney is not immediate and then someone becomes incapacitated, then there could be an argument amongst family members about, well, what determines capacity? And to avoid that hiccup or that headache, I like to make my general power of appointments immediate, such that that agent can immediately make financial decisions. And what's really nice is, when you put that document together, you get to decide. You can say, yes, this agent has the ability to manage all my financial affairs, business interests, real estate, financial accounts, bank accounts, sports accounts. Or you could say, you know what, I'm just going to give this person, this agent, access to manage just my real estate, or just my finance, or just my financial accounts, or just my business interests. So you can make it as broad or as limited as you like. What's really great is you come into the office, we sit down and we talk about it step by step, and we help you make those decisions. And you should do that with any attorney that you work with. Healthcare power of attorney. Now, this is where you designate an agent to make healthcare decisions for you if you're unable to make them for yourself. Now, this is typically going to be your spouse or loved ones, but it's really important to know what kind of authority you're granting, because this healthcare agent is basically going to have life or death authority over you if you're incapacitated. So make sure that you name someone that you really, really trust. Also, when you fill out the healthcare power of attorney, you have the ability, and some people are very specific about their thoughts on artificial nutrition and artificial hydration. I've received paragraph-long statements from people who are either in the medical field or know someone in the medical field, and they've put in these specific limitations. So what am I saying? Well, when you create a healthcare power of attorney, you can give the healthcare agent full authority. But there's also a section where you can limit that healthcare agent's authority. And one area you can limit that authority is whether or not you should receive artificial nutrition and or hydration if you're incapacitated or if you're in a life-threatening situation. So give that some thought before you fill out those documents, do some research or ask your attorney for some guidance if you have some concerns or you want to put some specific limitations into your document for your healthcare agent. Living will or advance directive. Now, sometimes this living will gets confused with the last will and testament, and they're completely different. Okay, the living will, if you're a little bit, I say seasoned, and you've heard of a woman named Terry Schiavo, there was a case where Terry Schiavo was incapacitated, and then there was a big dispute between her husband and her family members about whether or not she should be taken off of life support. Okay, a document like this, the living will or advance directive, will make that clear. Okay, it will say, my desire is to have a natural death, and my doctors shall not take extraordinary measures to save my life, meaning I should not be hooked up to any machines. Or my doctor may, if I'm in a vegetative state, may hook me up to a machine and perform life preserving measures. So that living will or advance directive is a great document because it makes your intentions clear. And what's nice is when you have this document, you get to say which controls. Does the healthcare power of attorney control, or does the living will or advance directive control? You get to make that decision. I tell you what, when a husband and wife or a married couple come in to make that decision, there's some interesting conversation that takes place, but it's a good conversation because these are just real things that should be spoken about and decided upon before you need them. All right, what should I do next? Send me an email, greg@triclawyers.pro, greg@triclawyers.pro. We can schedule a 15-minute consultation. This is November 17th, so we're getting close to the end of the year. There's still time. There's still time, especially if you're that person who said, you know what, this year, 2021, is going to be the year that I get my estate plan together, and you have not done that. I want to let you know that there is still time. Reach out to your local attorney, or if you're here in the North Carolina, Raleigh, Durham, Apex, Chapel Hill area, give me an email, greg@triclawyers.pro, and schedule that 15 minutes. I want to say thank you for joining me for this presentation. Estate planning is for everyone. As I always like to say, everyone has an estate, but not everyone has a plan. I hope you've enjoyed this, and hey, I'll see you next time. Take care.